right under Article 8, Section 1. But of course, if a right to education doesn't include a right to be prepared, or at least an opportunity to be prepared as a citizen, if it doesn't include at least an opportunity to go on to gainful employment or higher education, then it's hard to imagine what a right to education, especially a fundamental right to education, might mean. And I would direct this court to the long historical narrative of the constitutional right to education before 1965. Of course, in 65, it became constitutional. But the right to education, or at least the duty to educate, has existed in Connecticut since 1650. In the Ludlow Code, the same purposes expressed or echoed in paragraph 46 of plaintiff's complaint are in fact also expressed in the Ludlow Code. That's employment, that's citizenship. That court referred to the same basic notion in Bissell v. Davison in 1894 when it said, "The education of the youth is a necessity for the protection and welfare of the state itself." In Huntington, the court said, "Connecticut has for centuries recognized it as her right and duty to provide for the proper education of the young." It goes on. That history is specifically incorporated by Delegate Bernstein in 1965. Connecticut has, with its traditional good education, had no reference to it, the traditional good education, in the Constitution. He goes on to quote the Ludlow Code. He says, "We have that tradition which goes back to our earliest days." He goes on. It goes without saying, if we're going to have a representative government, education is the first and best way of promoting it. So the Delegate Bernstein specifically incorporated the long history of the duty to educate into the right. It appears that what the state is arguing and what the trial court concluded is that in spite of that history, in spite of the fact that there is clearly content to the word education, or specifically to the word schools in the text, that nonetheless plaintiff's claims must fail. And that's what we're saying was an incorrect determination of the trial court.
As a matter of record, did the plaintiffs seek to offer evidence once it was made clear the trial court was doing the Geisler analysis?
It was not made clear, Your Honor, until it had issued its decision. There was no discussion of the Geisler analysis prior to that point. So after that point, it had already been made clear that the trial court said under no set of facts, presumably that meant under no set of facts that we could present, even under the Geisler analysis, under no set of facts could plaintiff's claim prevail. And that's, in fact, why we appealed to this court. Now, I would also point to the fact that this court's decision in Horton implicitly recognizes that there is content to the notion of education. So this court in Horton was equalizing educational opportunities. Now, presumably, if this court had no concept of what the core meaning of education was, it would have equalized everything: landscaping, photo labs in schools, etc. But of course, the court wasn't equalizing everything. It was equalizing certain things in particular that go to the core notion of education. So the court already had to have a conception of what education meant before it could equalize education. And I think this implies, although not necessarily says directly, that of course there is content to the notion of education. And essentially, as long as there is content to the notion of education, plaintiffs have to succeed at this procedural stage. And that's really what we're saying as far as the textual argument. It's what we're saying as far as the historical argument, that of course the text uses the word schools, and schools has meaning. Of course, Delegate Bernstein referred to free public education, or free good public education. And I think a look to some of our sister states actually makes clear a number of the issues in this case. So I'd like to point the court to the decision of the South Carolina Supreme Court in the Abbeville decision, to the North Carolina Supreme Court in the Leandro decision, the Kentucky Supreme Court in the Rose decision, and the Massachusetts Supreme Judicial Court in the McDuffie decision. And if the court would like to look at the constitutional provisions in question here, they're on page A48, A44, and A46 of the defendant's appendix. So it's Kentucky, Massachusetts, South Carolina, and North Carolina. Now, it's 4 states. They use 4 different adjectives to describe their right. South Carolina said minimally adequate. North Carolina said sound basic. Kentucky said adequate. Massachusetts said an adjective is really inappropriate we're going to reject the notion that a word that is or is not in the Constitution is dispositive. So 4 different states, 4 different adjectives, 4 different constitutional provisions. South Carolina and North Carolina, very, very similar, almost identical to Connecticut. Kentucky, rather different. Massachusetts, rather different. All 4 of these states, 4 different adjectives, 4 different provisions, 4 identical definitions of the right to education. All 4 of those states adopted the so-called Rose factors from the Kentucky case. I would add to this the New York Court of Appeals in the CFE case, which with an almost identical provision to Connecticut's, found a right to sound basic education. Now, certainly the state tries to say, well, sound basic's not the same as suitable. Those are 2 different things, aren't they? Frankly, we don't see any distinction. Whether it's the word proper from Huntington or the word good, whether it's the word suitable or whether it's the word sound basic.
Isn't all this just a bunch of semantics, though?
Exactly. That's exactly our point, Your Honor. It's the meaning of the right to education, and that's, of course, in all these states to prepare students for the world beyond high school. Now, there have been some differences in the way the 18 sister courts that have found content to their right. There have been some small differences in the way they've defined these rights. But ultimately, all these states basically said, you've got to prepare kids. You've got to prepare them as citizens. You've got to prepare them to find gainful employment. And if you don't, it's not an education in any meaningful sense. And this is really what plaintiffs are saying here. And so what we can't understand is how a fundamental right to education doesn't offer those basic guarantees, especially when every court to have examined the fact found that it does, in fact, contain those basic guarantees. I think to conclude, I see my time's running short, and I want to make sure my co-counsel has an opportunity to address this court's justiciability concerns. I think to conclude, I'd like to make the point that however you define it, a fundamental right to education has to have content. And to find that it has no content is clearly in conflict with both the long history of this state's duty towards public education and this court's holdings in Horton and its expansive discussion of the importance of education in the CCJEF case.
What is the significance of the term appropriate used before legislation, if any?
The significance of that term, as explained by CCJEF, is that it is this court's duty to determine what is and what is not constitutionally appropriate legislation. And so appropriate modifies principle. The legislature shall implement this principle, the principle of public education, by appropriate legislation. And, Your Honor, what we're claiming again is that certain legislation is in fact not appropriate to the principle of public education and to the content of that principle.
You're arguing that the term free public elementary and public schools is not solely a neutral term, but inherently contains some qualitative standard?
Absolutely, Your Honor. Specifically, the promise that students will enjoy, at least to some extent, the fruits of education. And if they're not enjoying the benefits of education, then it's not an education. It's not a school to refer to the text. And now, if the court has no further questions, I would point it to its admonition in State v. Dukes. The Connecticut Constitution is an instrument of progress, should not be interpreted too literally or too narrowly so that it fails to have contemporary effectiveness.
Counselor, I have a quick question. What's your understanding in terms of what the trial court actually concluded? What would you say the holding of the trial court was in the case with regard to the primary claim you're making?
The holding was that there is, in fact, no such content to Article 8, Section 1.
Do you read his opinion as suggesting, that there's no content at all?
That there's no such content.
Not just that it's not suitable, not just that the suitability test is not appropriate, but that there's no content at all?
Well, it appears on the one hand that he's saying that. However, on page 39 of the decision, he does in fact seem to concede that there are some things that a school district could deny, for example, ESL services, which in fact is in our complaint as a claim about at-risk students in paragraph 76. But the court makes a concession that, of course, as Justice Loisel said, the lone dissenter in Horton, you have to understand education reasonably. And if we denied ESL or if we denied various other services, I could imagine that that's a denial of the right to education. So that appears to concede that there is some